If the parties cannot agree on a mediator, they can contact a neutral organization such as the Arbitration Foundation of South Africa, also known as AFSA. AFSA will be willing to appoint a mediator from their panel of accredited mediators. Well, obviously, mediation is a voluntary process, which means that nobody can be compelled to proceed to mediation. However, parties should bear in mind that there's a new Rule 41A that's just come into effect from February 2020, where parties have to declare to the court that they have made an attempt to resolve their matter through mediation and weren't able to do so. If mediation has not been considered by the parties, the court itself is obligated to recommend mediation if it deems it appropriate. In most cases, the parties will share the cost of the mediator, but in some cases, such as a divorce case, one party may pay for the entire cost of the mediation. Although mediation has a high chance of settlement, the parties do not always settle their dispute through mediation. However, just because your mediation session did not result in a settlement does not mean that all settlement possibilities are off the table. I suggest that you talk to your mediator to keep the channels of communication open between the parties, whereupon some proposal may be considered down the road. Just keep in mind that the longer the mediation or the dispute goes on, the more expensive it will be to resolve. Typically, mediations will be confidential, and you can make sure of this by checking for a confidentiality clause in your agreement to mediate. If you don't see a clause on confidentiality, or you don't have an agreement to mediate, you can ask your mediator to create one. Technically, you don't need a lawyer to represent you, although you can bring one along if you feel the need. The difference between a mediation and a litigation is that most parties are trying to resolve their dispute, not trying to present evidence to a judge or an arbitrator. The result is that you don't need the lawyer to present your case. If your case involves complex legal rights, you may want to consult with the lawyer before the mediation to discuss the legal consequences of possible settlement. You may also want to get your lawyer to review any agreement that you reach in mediation before you sign it. Since mediation is a much more cost-effective and expeditious way of resolving a dispute, you are well advised to try and resolve your dispute through mediation before proceeding to litigation. Also keep in mind the new Rule 41A of the High Court rules, which make it mandatory for parties to consider and try to resolve their dispute through mediation before proceeding to litigation. While not all disputes are capable of being settled, a surprising number of disputes can and do settle once the parties become open to settlement.